Welcome to the deep dive. Today, we're tackling a really core issue in American law, free speech. Specifically, that tension, between expressing ourselves and the government's need to protect the country.
Right, and you, our listeners, brought us a fantastic set of legal cases to work with. We're going to use these to really unpack how this balance works, or sometimes doesn't work.
Exactly. Think of it as your personalized tour through some major free speech moments. And we're anchoring it all around one key case, right?
That's the plan. Our main focus, our kind of reference point, will be Schenck v. United States. It's from 1919 World War I era.
Ah, the clear and present danger test case.
Precisely. That's
Okay.
the big takeaway from Schenck. And we'll be looking at how that idea plays out or gets modified in the other cases you've brought up.
Okay, so let's really zero in on Schenck first. For you listening, this involves a guy named Charles Schenck. He was involved with the Socialist Party in Philly, and he got into trouble under the Espionage Act of 1917. What exactly did he do?
Well, Schenck was part of organizing the printing and mailing of about 15,000 flyers. These were aimed at men who were eligible for the draft during World War I.
And what did these flyers say? Were they just, complaining about the war?
They were pretty direct, actually. They argued that the military draft was unconstitutional, basically calling it involuntary servitude, which is banned by the 13th Amendment.
Wow, okay. Strong language.
Definitely. And the flyers urged the recipients to resist the draft. They did mention using rights like free speech and petitioning, but the overall message was clearly, assert your rights, resist this. It was framed as upholding the rights of the people against this unjust system.
So it wasn't just abstract political debate. He was actively telling people, don't go along with the draft. And this is happening during a major war.
Exactly. And that's where the Espionage Act came in. That law was specifically designed to stop people from interfering with military operations, or, crucially, recruitment.
So the government saw Schenck's flyers as doing exactly that, obstructing recruitment.
That was their argument, yeah. Willfully obstructing the recruiting service of the U.S., potentially harming the war effort. They saw a direct line between the flyers and undermining military readiness.
Which leads us right to the big question in Schenck, and really the question hovering over all these cases today. Did convicting Schenck for sending these flyers violate his First Amendment right to free speech?
That's the core tension. Where's the line? Especially when the government says national security is at stake.
And we'll see how that line gets drawn and maybe redrawn in the other cases your listeners brought us. Let's quickly list them again.
Sure. We've got 303 Creative. That's the recent one about the website designer and compelled speech. Then Brown v. Entertainment Merchants Association on violent video games and minors.
Right. And Counterman v. Colorado about online threats.
Yep. Also Snyder v. Phelps, the funeral picketing case. And finally, Texas v. Johnson, the flag burning case. Quite a range.
It really is. Okay, back to Schenck. Justice Holmes wrote the opinion unanimously and introduced this clear and present danger test. For you listening, this was a big deal, shifting focus from just the words to their potential effect.
Right. Holmes basically said, context is everything. What you can say safely in peacetime might be totally unacceptable during war if it poses a direct threat.
So what is a clear and present danger? What does that mean practically?
It means speech isn't protected if it's used in such circumstances and is of such a nature as to create a clear and present danger that it will bring about the substantive evils that Congress has a right to prevent.
Well,
In Schenck's case, the evil was obstructing the draft during wartime.
and he used that famous analogy, didn't he? Shouting fire.
Yeah, falsely shouting fire in a crowded theater and causing a panic.
Hmm?
He argued that's not protected speech because the intent and likely result is harmful chaos. Similarly, speech intended to incite illegal acts, like resisting the draft during a national crisis, wouldn't be protected. The immediacy and severity of the potential harm were key.
So for you listening, it's critical to remember that wartime backdrop for Schenck. The court explicitly said the standards are different when the nation's survival is perceived to be at risk.
Absolutely. National security was the paramount government interest, and it heavily influenced the reasoning. Schenck set this precedent that speech could be punished based on its likely consequences in a specific, dangerous context. That focus on impact is something we'll track through the other cases.
Okay, let's jump forward almost a century to 303 Creative LLC v. Elenis from 2023. This feels very different. It's about being forced to create speech, right? Not punished for speech already made.
Exactly. That's the fundamental shift. In Schenck, the government was punishing speech it saw as dangerous the flyers criticizing the draft.
Hmm.
In 303 Creative, the issue was whether Colorado's Anti-Discrimination Act, or
Hmm.
CADA, could force Lori Smith, a website designer, to create wedding websites for same-sex couples, even if it went against her beliefs.
So she argued creating those websites was speech, and forcing her to do it violated her First Amendment rights.
Correct. She saw it as compelling her to express a message she disagreed with through her artistic work. So it's punishment versus compulsion. Very different scenarios.
But is there any similarity in the government's goal? The underlying interest the state was trying to protect.
You could draw a parallel there, yeah. In Schenck, it was national security. In 303 Creative, Colorado argued it had a compelling interest in ensuring equal access to businesses and services for everyone, preventing discrimination based on sexual orientation under CADA. That's a significant state interest, aiming to protect civil rights.
Okay, so both cases involve the government asserting a strong reason for its actions related to speech. But the outcome was totally different. The court sided with the designer in 303 Creative. Why?
The key reasoning in 303 Creative centered on the idea that the First Amendment doesn't just protect your right to speak, but also your right not to speak. The court viewed the creation of custom websites as inherently expressive as Smith's original speech.
So forcing her to create a site endorsing a message she opposed was compelling speech.
Precisely. They relied heavily on cases like Hurley, involving the Boston St. Patrick's Day Parade, where the court said the organizers couldn't be forced to include a group whose message they didn't want to convey. It's about the autonomy of the speaker to control their own message. That specific right not to speak wasn't really the issue in Schenck, which focused on the dangerous consequences of speech that was spoken.
Interesting. So the focus shifts from the potential harm of speech in Schenck to the speaker's autonomy and the nature of compelled expression in 303 Creative. Okay, let's move to Brown v. Entertainment Merchants Association, the violent video game case from 2011. Here we're back to regulating content, but not in wartime. How does this relate to Schenck?
Well, like Schenck, Brown involved the government trying to regulate speech based on perceived harm. California argued it had a compelling interest in protecting children from the potential negative effects of violent video games. So you see that parallel again. Government trying to prevent harm.
But the context is obviously different, protecting kids versus national security. Did that difference matter in how the court analyzed it?
Hugely. The court applied strict scrutiny in Brown. That's a very high bar. Basically, the government has to show its law serves a compelling interest and is narrowly tailored, meaning it restricts no more speech than absolutely necessary.
And that strict scrutiny wasn't really the framework in Schenck.
Not explicitly, no. The wartime context in Schenck arguably lowered the bar, or at least made the government's interests seem overwhelmingly compelling. In Brown, dealing with video games outside of a national crisis, the court demanded much stronger justification.
Why apply such a tough standard to regulating violent games for kids? For you listening, this tells us something about how the court views different types of content.
Because the court didn't see violent video games as fitting into any existing category of unprotected speech, like obscenity or incitement. The justices have generally been very hesitant to create new categories of speech that get less protection. They pointed this out in a case called United States v. Stevens 2.
So California couldn't just say violence is bad for kids and restrict it.
Essentially, no. California tried to draw parallels to obscenity cases like Ginsburg v. New York, where restricting obscene material for minors was allowed. But the court in Brown said violence isn't the same as obscenity. They found the studies linking violent games to harm weren't convincing enough to justify the broad restriction on speech, especially since video games like books and movies are considered protected expression.
So, unlike Schenck, where the speech was seen as a direct threat to a vital wartime function, the court in Brown saw video games as protected expression, and California didn't meet the high burden to justify restricting them, even for minors. Okay, now what about Counterman v. Colorado, another recent one, 2023, dealing with true threats? How does that link back to assessing harm, like in Schenck?
Both cases involve figuring out if speech crosses a line into harmful territory. But the type of harm is different. Schenck was about potential harm to the nation, the war effort. Counterman is about threats aimed at a specific person in this case, a musician receiving disturbing online messages over several years.
And the big question in Counterman was about the speaker's mindset, right? Does the speaker have to intend to threaten someone? Or is it enough if a reasonable person would feel threatened? For you listening, this gets into how we define harmful speech.
Exactly. And the court landed somewhere in the middle, leaning towards needing some level of subjective awareness from the speaker. They ruled that for speech to be an unprotected true threat, the prosecution generally needs to show the speaker acted with at least recklessness, meaning they consciously disregarded a substantial risk that their words would be seen as threatening.
How does that compare to the clear and present danger test? Schenck seemed more focused on the likely result of the speech, not Schenck's specific mental state about causing danger.
That's a key difference. The Schenck test was more objective in that sense. Would this speech, in this context, likely cause the harm Congress wanted to prevent? Counterman introduces a subjective element for true threats, requiring that the speaker understood, or was reckless about, the threatening nature of their words.
Why add that subjective layer? Why not just ask if a reasonable person would be scared?
The concern was chilling protected speech. If people could be prosecuted for threats based purely on how someone else interpreted their words, even if they genuinely didn't mean them as threats, they might become afraid to speak forcefully or use hyperbole, especially online.
So it protects speakers from being punished for misunderstandings or poorly chosen words, unless they were at least reckless.
Right. The court looked at precedents like Watts, involving political hyperbole against the president, and Virginia v. Black on cross-burning, which also required an intent to intimidate. The Alonis case also pointed towards needing proof of the speaker's mental state for federal threat convictions. So it's an evolution from the purely impact-focused test in Schenck, at least in the context of individual threats.
Okay, so Schenck, potential impact on national security, context-driven. Counterman, threats to individuals requiring speaker recklessness. Got it. Now, Snyder v. Phelps, the Westboro Baptist Church case from 2011. This one feels particularly raw, picketing a soldier's funeral. How does this balance of interests compare to Schenck?
It pits free speech rights directly against the profound emotional harm inflicted on a grieving family. In Schenck, the harm was tangible, obstructing the draft. In Snyder, the harm was severe emotional distress. The court had to weigh the church's right to express its views, however hateful, against the state's interest in protecting individuals from that kind of pain.
And the court ultimately protected this speech, right? Even though it was happening at a funeral and was incredibly offensive, that seems quite different from the outcome in Schenck.
It is a very different outcome, and it highlights how strongly the court protects speech on public matters. The key factor for the majority in Snyder was that even though the picketing was vile, the signs address broader issues: homosexuality in the military, the moral state of the U.S., which the court classified as matters of public concern.
So because the topic was public, even the hurtful way it was delivered at a private, solemn event was protected. For you listening, that's a crucial distinction the court makes.
That was the majority's reasoning, yes. They argued that speech on public issues gets the highest level of First Amendment protection, even if it's offensive or causes distress. They drew parallels to cases like New York Times v. Sullivan and Hustler v. Falwell, which set a very high bar for punishing speech about public matters or figures, even if it's false or outrageous.
What about the fact they were right there, near the funeral? Didn't the location and the targeted nature matter?
It mattered greatly to the dissent, but the majority focused on the fact that the picketing occurred on public land, following police instructions, and addressed public issues. They felt that restricting the speech based on its offensive content or the emotional reaction it caused would be too dangerous a precedent for public debate. In Schenck, the perceived immediate threat to a government function in wartime overrode those concerns. Here, the court prioritized the public nature of the speech content.
Wow. So even extreme emotional harm wasn't enough to overcome the protection for speech on public issues in a public place. Okay, final case. Texas v. Johnson, 1989. Flag burning. This is symbolic speech, not words like in Schenck. How does that comparison work?
Right. Johnson deals with expressive conduct, burning the flag as a political protest. Texas argued it had an interest in preserving the flag as a national symbol, which you could, maybe loosely, compare to the national security interests in Schenck. Both involve protecting something core to the nation's identity or function.
But again, a different outcome. The court protected the flag burning.
It did. The court recognized Johnson's act as symbolic speech intended to convey political message dissatisfaction with government policies. Unlike Schenck, where the content of the flyers was deemed dangerous because it urged illegal action, the court in Johnson focused on whether the act of burning the flag was inherently expressive.
And they decided it was. What makes an action speech in the eyes of the court? For you listening, this helps understand how actions can get First Amendment protection.
The key test is whether there's an intent to convey a particularized message and whether the likelihood is great that the message would be understood by those who views it. Given the context of political protest, Johnson's flag burning clearly met that test. The court distinguished this from acts that are primarily conduct with only an incidental speech element, like the draft card burning in O'Brien.
So they looked at the intent and the context, much like they did with Schenck's flyers, but concluded the expressive nature of flag burning was protected, even if offensive to many.
It's exactly. The court emphasized that the government can't ban expressing an idea just because it's offensive. While Texas had an interest in the flag as a symbol, that interest couldn't justify suppressing political protest expressed through this symbolic act. It reinforces that high bar for restricting speech, especially political speech, outside those very specific, dangerous circumstances, like in Schenck.
Okay, so looking across all these cases, starting with Schenck, what are the big takeaways for you, our listener? It's clear free speech isn't absolute. Schenck showed that.
Definitely not absolute,
Right.
but the bar for restricting it is generally very high. Schenck's wartime context made a huge difference. Since then, the tests have evolved. We see different standards for compelled speech, 303 Creative, content regulation Brown, true threats, Counterman, offensive speech on public issues, Snyder, and symbolic speech, Texas v. Johnson.
The clear and present danger idea seems less like a single test now and more like one factor in a broader analysis that considers context, intent, the type of speech, and the specific government interest.
That's a good way to put it. The court is often balancing competing interests: national security, protecting kids, preventing discrimination, ensuring public safety, preserving symbols. These are all legitimate government interests. But they have to be weighed very carefully against the fundamental right to express oneself.
And the court seems really hesitant to carve out new exceptions or categories of unprotected speech, like we saw in the video game case.
Very hesitant. And we see strong protection for political speech, even symbolic or offensive political speech, as long as it doesn't cross into things like direct incitement, true threats, or defamation under existing standards.
This deep dive, starting with Schenck, really shows how dynamic this area of law is. The principles are debated and refined constantly as society changes.
Absolutely. Which brings us to a final thought for you listening. We've seen how these principles were applied in context from World War I pamphlets to modern websites and online messages. As communication keeps evolving, think AI, virtual reality, whatever comes next, and society faces new challenges, how do you think these foundational ideas about free speech will hold up? What new dangers or compelling interests might arise, and how should we balance them against this fundamental right?
That's a lot to think about. Where will the lines be drawn in the future? We hope this exploration helps you think critically about those ongoing debates. Thanks for joining us on The Deep Dive.